Hi. So we begin with our Insolvency and Bankruptcy Code 2016. Now this will be helpful to you whether you're in old syllabus or new syllabus, because ultimately you have to study Insolvency Bankruptcy Code. Also, it is not only helpful for your CRVI, it is also important and very necessary for your open book insolvency paper. So let's begin. This sheet I will be sharing with you all on our website Jahangir Tutorials. You can go ahead and download it. I will be doing it after this session gets over, and you can get access to this. It is highly advisable to get it printed and even browse through before going to your examinations. So let's begin. The Insolvency Bankruptcy Code 2016. So what is this code and why was it important? So very first thing, keep noting down things which you will quote in your exams also. Okay, so IBC code is a comprehensive law which talks about insolvency and bankruptcy in India. So insolvency and bankruptcy, insolvency could be for corporates and bankruptcy is generally for individuals and partnership firms. Okay, now for the IBC code, they had constituted a special committee called as a BLRC committee, or the Bankruptcy Law Reforms Committee, under the chairmanship of T.K. Vishwanathan. All this we will write in the exam. This is the beautiful introduction that IBC code, insolvency and bankruptcy. Insolvency is for corporates and LLPs, whereas bankruptcy is for partnership firms and individuals. So this is for firms and individuals, and the same term we use for company or LLP, we use the word insolvent. For individual, we'll use corporate. So IBC code in India is a comprehensive law for insolvency and bankruptcy. It was brought in through the committee, BLRC committee, okay, and under the chairmanship of T.K. Vishwanathan, okay. Now, again, I want you to quote it in the exam, that what is the object of the act or the preamble of the act. Okay, so we will definitely be writing it, that the main objective of the IBC code is, you will see the word liquidation is not there. The main objective of this, when a company is coming to for insolvency, we will try to revive it. Okay, so the main act, IBC code, is made so that in a time bound manner. So they give you that particular IBC matters will get over max in 330 days. So the tenure they have told is 330 days. It has to mandatorily get over the entire revival of the company. The main objective we want is that in business, obviously there is risk, so we want to promote entrepreneurship, okay, and establish IBBI. Sir, what is IBBI? It is a board which contains, which covers all the laws, all the amendments, all the authorities are covered under the IBBI. So IBBI is your authority, just like SEBI is for stock markets. All insolvency laws in India and control of all the IBC authorities are by the IBBI. Sir, why was this Insolvency Act passed in the first place? Why did he not continue with the older acts? So basically what happened is, this is the time to resolve insolvencies. Now see, this is the time. So you can write this, that the main reason why they brought in the IBC code 2016, in 2015 World Bank stats, see what it was there before the act. The time to resolve any insolvency, if any insolvency happened and the creditor took the company to court, in UK it used to get over in one year. Matter used to end in 1 year. In Brazil it used to go in 4 years. In USA it used to go in 1.5 years. Matter is closed. But in India, it should take 4.3 years for one case to get over. So then they said, we want a time bound case to close the matter. Not only that, we saw the recovery amount. What is this? If you go to see the recovery amount, the low recovery rate of 26.5 means what? For every 100 rupees, okay, 100 rupees lent, what happened is, imagine in USA they could recover, the creditors, if they were 100 rupees due, they could recover 81. Okay, in UK 85 means if they have given a loan, they get it back. However, in India, the stats was only 25. So looking at the low recovery rates that we had and the time to file cases in for the creditors, it wasn't very country where we had efficient system for recovery of debts. Then they said that let's do something, we need to make our country better. So what did we do? We introduced the IBC code 2016. So beautiful, we understood the object of the act. It is to promote entrepreneurship, it is to establish IBBI, it is to revive and restore the company, etc. Now IBC code 2016 has in total 255 sections. So it's not a very big act. It is 255 sections divided into 5 parts. Now from exam point of view and from your personal point of view, the most important part is your part 2. Why? Because it talks about insolvency of corporates. So when a LLP or a company is getting insolvent, the entire process is covered under part 2 of IBC code 2016. Now part 3 talks about individuals and partnership firms. Okay, individuals and partnership firms, and part 4 talks about the authorities and regulators under the IBC code. Okay, so part 1, 2, 3, 4. What are the authorities? We will see in some time. Okay, so here when we go to part 2, 4 to section 77A. So now let's look at the section list. Even in your part 2 of your IBC, from that also we need to know chapter 2. So this I want you to quote in the exam. Part 2 chapter 2. Can we quote that much? Part 2 chapter 2. Part 2 is about corporate liquidation and resolution of corporate persons. And chapter 2 talks about CIRP, and it is from section 6 to section number 32. If we could not do revival of the company, then the very next chapter is there that we will go ahead and liquidate the company, section 33 to 54. So this much I want you to quote: part 2 chapter 3 and 4, section 6 to 32A and section 33 to 54. All this I want you to quote. Okay, that's it. Now let's see, there are certain form numbers also I want you to write and quote in your exams. Okay, so now remember that whenever there is an insolvency, case can be filed. For example, a company is becoming insolvent. So who will file the case? Obviously the creditor will file the case. Now financial creditor is a person who has given a financial debt or a loan. Financial debt means what? Where it is shown by interest. Delay is shown by interest. Okay, so he will file in form 1 section 7. So sir, form numbers, yes, you have to quote, note it down. Now second is operational creditor. Operational creditor is section number 9 and form 5. So what is form 5? Form 5 is basically when a operational creditor. So who is a operational creditor? Is a person who's given an operational debt. Sir, what is operational debt? A debt is basically, operational debt is where money demand is coming for from basis of good supply of goods and services. So for example, if I have supplied goods to you and you have not paid the money, I am a operational creditor. If I have given you services such as salary or for employee also, so they will be operational creditors. So two kinds of creditors are there recognized under the IBC code. Financial creditors, that is your lender of money, loan, and operational creditors, those who have given services of goods. So form 1 and 5 we will write it down. All I want you to note down. Okay, and form number 6 is the corporate debtor can also file a CIRP process for insolvency process. Sir, why will he file? Corporate company himself will go and go to the government and file. Yes, what happens is the corporate debtor will go and tell the government that listen, in the Object Act it is written that you will try to revive me. Please revive me. So the section numbers are sorted. Okay, section 7 is for financial creditor and will be in form 1. Form 5 will be for operational creditor and section number 9, and form 6 is for corporate data, section number 10. All the sections I'll make you learn, don't worry. Okay, now as we saw in your part 4. Sir, what was part 4? Part 4 is about authorities and regulators. We are seeing that. So which are the authorities under your IBC code 2016? First is the adjudicating authorities. It is the adjudicating authority. Adjudicating authority means what? If an insolvency case will go where? If it is with respect to a company, it will go to NCLT, and if it is with respect to an individual or partnership firm, that is a non-corporate entity, entity not having separate legal existence, they will go to DRT. Appeal from NCLT will go to NCLAT, and from there it will go to Supreme Court. In DRT, it will go in appeal to DRAT, and then it will go to Supreme Court. So these are your courts which they have given. And now coming to your other authorities. So your first and the most important is your IBBI, Insolvency Bankruptcy Board of India. So what it is basically a regulator for insolvency matters in India. It recognizes all these three authorities. Okay, it has the powers of a civil court or for matters of for summons, witnesses, etc. They recommend the entire laws, etc. So this is done. Now we come to insolvency professionals. After completing CS, after doing your CA, after doing a CMA, you can register yourself with the IPA. IPA is basically just like how you have ICSI. There is a ICSI IPA, ICAI IPA, and ICWA IPA. So these are all our institutes have registered themselves as a Section 8 company and are conducting insolvency examinations. Once you conduct an examination, they will give you a membership and you will be a registered valuer. If you do something wrong, professional misconduct, then they will suspend or cancel your license, reprimand you. So all those things what ICSI does on us, IPA will do on insolvency professional. Insolvency professionals are those who will be appointed to revive the company and prepare certain resolutions plan. And the last authority that is there is called as information utility. So what is the information utility? Information utility is an authority or is a body that will collect and collate the information of the corporate debtor and his assets. What happened is Vijay Mallya, he ran away from the country. The creditors didn't even come to know. So now they have made a special authority. They have made a special body which job is to keep track of all the creditors, of all the debtors and their assets, that they do not end up alienating or running outside India. So it has all the information about the debtor and his assets. So what is the entire flow of the chapter? What is the entire IBC? What happens here? Okay. So let's see. Insolvency will be, first there has to be a default. A company which is completely into profit, not making any default, cannot come before IBC code 2016. Clear? If everything is good, a profit making company, a company which has never made a default, can never come before IBC code because it doesn't look like any problem. The entire scenario, the entire process starts from a default, payment of default. So there must be the creditor, he must not be able to pay the money. If he has not been able to pay the financial creditor, he couldn't pay. Even one EMI is bounced, the financial creditor can go directly and file a case to the authority, NCLT. Similarly, on default, if he himself felt embarrassed, corporate debtor, he knows that his future is little doubtful and he requires some help from NCLT, then corporate debtor can also himself go to and initiate the CIRP process, that is corporate insolvency resolution process. So company is getting insolvent, we will try to revive it, that is the process. Okay, so corporate debtor will go in section 10, financial creditor will go in section number 7. Sir, where is section 8 and 9? So that is for an operational creditor. So imagine a supplier of goods and service. If we have defaulted to make a payment to him, he cannot directly go to NCLT, he has to give a demand notice, okay, under section 8, and then in section 9 he will file a case to CIRP. So demand notice is given under section number 8, that he has to give a legal notice that better pay me my money, otherwise I'll go and complain to NCLT. And demand notice form also, please note, section number 3, form 3, okay, is, so I want you to remember these form numbers and quote it. mandatorily in your examination. Okay, so not many students are going to write, but you will write because you are my student. Form 1, 3, 5 and 6. Form 1, 3, 5 and 6. Financial creditor, operational creditor filing a petition, demand notice is in form 3 and corporate data files in form number 6. Okay. Now, once they file an application to NCLT, okay, once they file an application to NCLT, then what happens? Pay attention. Then NCLT gets 14 days time to admit the application. How much time does NCLT get? 14 days time to admit this application CIRP process, and they will then do 3 things. Okay, they will appoint a IRP in the matter. They will say, okay, this person is an interim resolution professional. Interim resolution professional will be appointed. This interim resolution professional will go ahead and make a committee of all the creditors. He will find out who all money is pending. He will make an entire committee that will come, and then the committee of creditors will then form and appoint a RP. Sir, process again. So you file an application, goes to NCLT, then NCLT admits the application. After admitting the application, NCLT is not going to do the work. They appoint a IRP. IRP will make a committee of creditors, and that committee of creditors will then say that whether they want to continue with the interim guy or they want to appoint a new RP. Okay, sir, after the RP is appointed, what will happen? Now the RP will invite resolution plans. What he will do? He will tell various resolution applicants. He will tell various investors. The investors are called as resolution applicants. That do you want to invest? Are you ready to buy? This company is getting sick. It has a good brand name. You can invest. We'll give you a discount. He will try to sell. He'll try to invite various plans for revival. If we receive a plan, well and good, the plan is approved, the matter will be resolved. Okay, if the plan could not be, we didn't receive only any plan, then we'll go for liquidation. So if I summarize, what happens here is application is given to for CIRP. Then CIRP appoints a authority, IRP. Then IRP will form a committee. The committee will then appoint the RP who will invite resolution plans. If we get the plan, matter is resolved. If we don't get the plan, then we will have to proceed for killing the company completely, which is called as liquidation. Okay. Now, as I told you, sections are important. So, chapter 2 is important. Okay. Chapter 2. Very, very simple. Which sections I told you is important? Section number 7. It is where the financial creditor files a case. Initiation of CIRP by financial creditor. The corporate the operational creditor cannot directly file. He goes in section number 8. He files in section 8, he has to give a demand notice. If in demand notice within 10 days, we have not received the money or we have not received any reply, then he will go in and file a CIRP application in section number 9. 10 says corporate debtor himself goes on and files a case. 11 says who cannot file an application if CIRP application was already pending or it is already dismissed earlier, so they can't go. Time limit for completion of CIRP. So very, very simple. 180 days plus 90 days. If within that much also not, then you get more 360 days. So in total, the entire CIRP will get covered over in 330 days. Okay. Now, moment the CIRP application is accepted by NCLT. Moment it is accepted, 3 things will happen. Now pay attention to this. Okay. Now, moment NCLT picks up the application, then 3 things will happen. For example, these people, they came and they ran to NCLT, say that please help us revive. Any of them. Financial creditor under section 7, in section 9, this guy, what's his name? Operational creditor, or in 10, that corporate data. Once he comes to NCLT admits the application, automatically 3 things will happen. A moratorium period will happen. Okay. A public announcement will be made and a IRP will be appointed. 3 things happen. So first is a moratorium. Moratorium is now no case can be filed, no suit can be filed, no enforcement order can be filed against the company. A public announcement will be made by IRP will come. IRP will be appointed by NCLT and he will file a public announcement that whoever's claims are there on this date, you will come and give the claim. I'm making a claim list. I'm doing all this to prepare a committee of creditors. Committee of creditors. I'm constituting the committee of creditors. So NCLT appoints IRP. I told you IRP will come. What is his job? His job is first to constitute a. We'll see all these basic things are there. That he will, all the powers of the directors he will have. Okay, he will be there till the committee of creditors select the RP. Once the committee of creditors are there, his job is done. Duties of the interim resolution professional. So IRP will come. His job is to make a committee of creditors, figure out who is the financial creditors. Okay, all of those he has to collect all the list, etc. All the persons are required to give cooperation to the resolution professional, and in 20 management of the operation will be done on a going concern basis. Sir, what do you mean by going concern? Even though if it is taken in CIRP process, doesn't mean that the company cannot function. Company's day-to-day operations will go on. Okay, no one can file any action against the debtor without the consent of the IRP. So moratorium is there, but that doesn't mean that the company will not function. Now IRP's main job is to appoint a committee of creditors. So committee of creditors will be formed with all the financial creditors. We will form a committee of creditors. They will have their first meeting of committee of creditors, and then they will appoint a RP. Sir, what is the committee of creditors? What will they do? They will appoint a resolution professional. Sir, what is the duty of a resolution professional? So the resolution professional's main job, is to prepare something called as an information memorandum. Sir, what is information memorandum? They will prepare an entire data about the company, how many creditors are there, how many issues are ongoing, all the assets of the company. Full information memorandum will be prepared. This information memorandum will be shared with investors. Okay, so investors can then give their resolution plan. Always remember, they don't call the word investors here, they call them as resolution applicants. So they are applying that they will revive the company, they will invest money into the company. So what's the main job of a resolution professional? The main job of a resolution professional is to prepare an information memorandum, to invite claims, and then settle the prepare a plan and then tell NCLT which is the final plan which has been accepted. So see, resolution plan, applicant submits the plan. So in section 29A, person not eligible to be resolution applicant. So they are telling you who cannot become a resolution applicant. Sir, what do you mean by a resolution applicant? Investor, who are not allowed to be investors into this business. A plan will be prepared. Plan has to be approved by 66% of the committee of creditors. Okay, they will tell you how many people will approve the plan. We'll just check the percentage. Okay, and that is it. Okay, if by 32A everything is not fixed, then the company will go into insolvency. So if you go back, what is the procedure? That application is filed, CIRP. Moment CIRP is filed, accepted, moratorium period will be announced. Moment moratorium period is there, IRP is also appointed. IRP will prepare a committee of creditors. The committee of creditors will appoint a resolution professional. This resolution professional will invite resolution applicants, they are investors, to give their plan. How do they want to go ahead? And after the approval of the plan from the committee of creditors, they will give it to NCLT to close the matter, and then the revival will happen within 330 days. If not, then the liquidation procedure will start. Clear? So let's begin with giving you the markings also. First, section number 1. This act applies to whole of India. Section number 2, as and when we come, I will tell you. Now, interestingly, section number 2 does not talk about definitions. Normally, always section 2 talks about definitions. But in IBC code, section 5, section 79, and one more section is there which talks about definition. And that is section 3. Section 3, 5 and 79 talks about definition. So what is section 2? Section 2 says this act applies to when? So this act applies to companies, as we did, company, LLP, individual and partnership firms. Okay, it applies to all of them. Simple. Now comes the definition. When we do that, we'll come to in the chapter we'll come to know. Now we see section number 4. So what is section 4? So it says that when can a case be filed in NCLT? The application of CIRP process. For a CIRP process, remember that the minimum default size is 1 CR. So the minimum default okay, size is 1 crore. So central government by notification says that the default of higher value of shall not be more than 1 crore. They will specify. So they have told 1 crore is the final figure. Okay. Beyond that, they cannot put that default amount. Now coming back to the definition, I told you 5 talks about the definitions. Section 6 says who may initiate CIRP process. I already told you that 3 parties can initiate insolvency process given in section 6. So creditors, financial creditor, operational creditor, and the corporate debtor himself can also initiate a CIRP process whenever there is a default. So default means what? Even 1 rupee default is allowed. What do you think? And does the default amount include the interest amount or only the principal we are counting? So the answer is a debt, whether whole or any part or installment. Any part or installment is not paid. Okay. So obviously it means any part of the debt, and debt includes interest. So even if you not paid one EMI, in CIRP can be started against you. Second, provided it is 1 crore threshold should be there. Okay. Then only it will be there. Now, as we did initiation of section 7. So how does it start? Section 7 is about moment the default is there of 1 crore or more, then you will anyone can file an application. That is here in section 7, the financial creditor will file a case and NCLT will either accept or reject the application. Okay. Section number 8, what does it talk? That operational creditor may on default deliver a demand notice. So operational creditor cannot on default, he cannot file a case. He has to give a note. He has to give a demand notice, and only the demand notice will be in 3 form number. Then he will have to wait for the response of the corporate debtor for a period of 10 days. So the corporate debtor shall within 10 days of receipt of the demand notice bring to the operational creditor 2 things: that existence of dispute or proof of payment. So he will say either I have made the payments, either electronic transfer, or he will say that why should I make the payment, goods were defective. If there is nothing like that happening, then obviously in section number 9, the CIRP process will be initiated by the operational creditor. Okay. So after the expiry of 10 days, the operational creditor does not receive a proof of payment or notice of dispute, then he will file a case before NCLT. He will file in form number 5. Okay, with all the details, etc. A operational creditor must individually meet the 1 CR threshold under section 4. Unlike financial creditors, operational creditor cannot combine their joint claims to file a joint application. Now remember one thing, that if there are 3 lenders, okay, now to touch that 1 crore threshold, 2 financial creditors are there. They have, each of them have given 60 lakhs. Individually they cannot file a case, but they can club themselves. Financial creditors are allowed clubbing joint application, but operational creditors are not allowed to file joint application. They have to individually meet the 1 CR threshold, because obviously the government is giving more preference and recognition and importance to financial creditors. Important point. Then we come to section number 10, where the corporate applicant himself, company himself realizes that he has defaulted. He will immediately run to NCLT to get moratorium stay, so none of his assets can be there, and NCLT will appoint a resolution profession to revive him. Okay, so he will file an application in form 6. Learn the form numbers in the beginning. He will give all his proof of default, and the NCLT, moment they accept it, within 14 days they will accept or reject. From that date, the commencement date will start. So one important line is there for all of them. CIRP commencement starts from the date of admission of applicants. For all of them, moment the NCLT accepts it, the CIRP process will start. Sir, what is it? That 330 days will start from that day. Okay, so that is why it is important. Now, person not entitled to make a application. Now, very sad, these people cannot do. Someone who is undergoing already CIRP, who is undergoing PIRP, who has completed, CIRP in the past 1 year, or who has got a plan approved in the past 1 year, okay, 12 months. So all these people, they have already done all these revival things with them. They are undergoing liquidation already. So then, or they have violated the resolution plan. So all these people, either they are undergoing already or they have just completed recently. So now we are not going to entertain all these sick people again and again to come to the court to revive them. Okay. Now, remember the time limit, section number 12. What is it? Section number 12 is the time limit to complete CIRP. So what it is, that within a span of 180 days, CIRP should be completed. If government wants, they can give a consent, they can give an extension of 90 days, further 90 days. So 180 plus 90, how much will it come up to? How much? 180 plus 90, 270, right? So within 270 days it should get completed. However, one more extension has been given, that more extension of 60 days. So if you add more 60 days, how much you get? So if I add more 60 days to this, then 330 days. So in total, the CIRP process has to be completed within 330 days. Now remember that last 60 days is not due to party's default, but if the court procedural delays are there, that is why that extra 60 days has been given. So remember, 70 plus 90 plus because after 90 they say no such extra extension will be given, but in very next line they say that more 30 days, 330 days it should be completed. That 60 days is for court delays. Okay, so that you can write and close it. If so, here is your threshold, that initial period is within 180 days CIRP process should be given. Extension can be given if committee of creditors have passed a resolution of 66%, then a 90 days additional period can be given, and in total, including all the legal proceedings, it must conclude within 330 days mandatorily. Okay, now obviously comes withdrawal. So in 12A, if any of them want to withdraw, they can withdraw their applications also. Now coming to very important, okay, very important. So first thing is NCLT, let's say, okay, now note this down. NCLT admits the application. What does NCLT do? It admits application. Okay, moment they admit the application, three things will happen. Sir, what? IRP will be appointed, insolvency resolution professional will be appointed, a moratorium period will be declared. Moratorium is like a stay order. Okay, and third, a public announcement will be made that this company is coming under this moratorium period. Now nobody can file a case against the company till we further order, till the CIRP process gets over. Okay, so now very important, section number 13, that the adjudicating authority, okay, after admission will do three things. They will declare a moratorium period, they will cause a public announcement, and they will appoint a IRP. Three important things will happen. Okay, then moratorium. Sir, what is a moratorium? So moratorium is a stay order during which the no new suit can be instituted, no transfer or disposal of assets will be done, no creditor can enforce their security interest. Okay, recovery of property by owner or lessor cannot be done. Okay, recovery of any property from the owner, lessor will not be permitted. Okay, However, essential supply. So when we say everything will stay, that doesn't mean the business will also stop. Essential supplies, etc., shall not be terminated, suspended during moratorium period. So whatever is needed will on go. Okay, on a going concern basis. Now, when moratorium will on the duration of the moratorium. So obviously till the resolution plan is approved or company has gone into liquidation. Okay, under section 33. Now section number 15, what does it talk about? I told you, one is moratorium we saw, okay, that no case, no enforcement, nothing can be done. Section number 15, a public announcement will be made that any they'll tell that this corporate debtor is under insolvency. This is the last day to submit your claim. This is your IRP. You can go and inform him. Okay, and they will also say that within 180 days we will complete this entire process. So be active. The third thing is IRP. Now, moment the IRP comes, his job is to first to find out whoever's money is left, who is pending, and they make a committee of creditors. So, who appoints IRP? So, financial creditors and corporate debtors have to mandatorily tell who the IRP is. Operational creditors may or may not give the name. Okay, so then the NCLT can either keep the IRP or they will ask IBBI to give an IRP, but there should not be any disciplinary action against the IRP. Common sense, they wouldn't keep anyone who has a disciplinary action going against them. Okay, now once that is done, then comes management of the affair. Now we're just seeing all with respect to this guy only, IRP. IRP will now have all the powers of the board of directors. All the powers of the board of directors have been suspended. So the board of directors automatically their powers have been transferred to the IRP. Now they will manage all the employees, everyone, every employee will report to the IRP just like they did to the BOD. The instruction of financial institution. The institution shall act on instruction of the IRP. So again, everybody, including the creditors, will now have to work on the instructions of the IRP. Now, the powers of the IRP is to execute all documents, run the company, get access to all the corporate records, electronic records, comply with all the laws. Now, it is his job to ensure that the company complies with the laws because all the powers of BOD come to him. Section number 18, duties of the IRP. What is the duty? So obviously his duty is to collect all the information about the business, prepare and collect and collate all the claims and form a committee of creditors. Okay. Now this committee of creditors will now decide the new IRP, whether they want an interim resolution professional to continue or they want to appoint a new RP. That new RP will then find plans, etc. This IRP only is there till the committee of creditors is formed. Okay, so everyone in section number 19, everybody has to listen to the IRP, cooperate with him, listen to his instructions, etc. Management of the affairs will be done on a going concern basis. He will have a right to appoint legal personnel, staff, amend contracts, raise interim finance, issue any kind of instruction to any employee, take necessary measures to ensure that it's a going concern. So IRP creates a committee of creditors. Now the committee of creditors, once the IRP is made, then they will decide the new RP, whether they want to continue or go ahead with them. See, the IRP collects all the claims and then constitutes a committee of creditors. This composition of committee of creditors, the committee of creditors shall comprise of all financial creditors only. If it is a related party, that person will not be allowed to vote. Okay. Now, this section number 21 is important. You can read it in depth also. Okay. All the access to the lectures are available in the Dream batch. You can go ahead and go through all this. Okay. We are just trying to complete the sections and try to memorize section form numbers which we can quote in the exam. Okay. Now, appointment of resolution professional. Once they are there, now I told you, committee of creditors, what will they do? The first committee of creditors meeting shall be held within 7 days of their constitution. Okay. They will appoint a RP, either as I told you, replace or continue the same guy. Resolution by the committee of creditors, they will pass a resolution to appoint a RP. Now the RP will be appointed. Section number 22. Sir, what will the RP do? Now the RP, here the revival process starts. The resolution professional is responsible for ensuring the CIRP process, that we get a plan and constitute. He will have all the powers of BOD now, just like the IRP had. Now he will have all the powers, all the information. He will conduct the meetings, etc. Okay. Now even operational creditors can attend the meeting, but they cannot vote. Okay, so all this also you have to read. Important duties of the resolution professional. So he will ensure that the assets are safeguarded, a proper list is prepared. He will see an information memorandum he will prepare under section 29A. So what is that? All the status of the affairs. Okay, maintenance of the list. He will prepare presentation of resolution plans. He will do. Let's see. 25. Okay, rights and duties of authorized representatives of the financial creditors. Okay, now just remember one thing, that financial creditors are there. Okay, financial creditors who have extended a loan, etc. Even your real estate allottees, like for example home buyers, simple word, home buyers are also considered as financial creditors. Now home buyers might be so much if the builder has cheated you. So all of them, they can appoint a authorized representative to represent them. And or we have even debenture holders. So they are also financial creditors. Now so many debenture holders will not come. They will all appoint a authorized representative, and the authorized representative have to act according to the these people. Okay. Now replacement, if this resolution professional doesn't do a good job, he can be replaced, okay, by 66% votes. Now coming to approval of committee of creditors for certain actions, or certain things are there require approval. Now we come to preparation of information memorandum. Sir, what is the information memorandum? All the information about the company will be kept here. Now obviously this access to information, so shall provide to the resolution applicant all the details. Sir, information memorandum, you can understand from the name itself, it gives a full information about the company. Now understand what happens if we see the full process. First is financial creditor, operational creditor or corporate data, they file a case before NCLT. Okay, NCLT. Now NCLT will then appoint a IRP on admission. Then moratorium will be declared. And one more thing is a public announcement will be given. Okay. Now once that is done, the IRP will now form a committee of creditors. This committee of creditors will then will appoint a RP. This RP will prepare something called as an information memorandum. Okay. Now this information memorandum will be shared with resolution applicants. Sir, who are resolution applicants? They are investors who will submit their resolution plan. Okay. So who submits the resolution plan? Resolution applicants. They submit it to the resolution professional, and then once a plan is received, it will require approval of committee of creditors and the NCLT. Okay, and then the process will close. Okay, so here we'll have to give all the information to the resolution applicant, the investor. Only then he will invest into the company to revive. Now the thing is, who is not allowed? Common sense, if you're undischarged, insolvent, you are willful defaulter or a non-performing asset. So such person is not allowed to act as a resolution applicant investor into the business. Okay, then your plan will be submitted. Submission of the plan. Resolution professional will examine the plan whether it covers the resolution cost to be covered, ensure that the operational creditors are paid. Okay, the priority of claims, the waterfall arrangement is given in your section 53, whether that order is maintained. Okay, it should be approved by 66% of the voting rights, and then it will be approved by NCLT. So till now everything is approval of this plan is given in section 31. The authority, if satisfied, will approve the plan. So till now everything is rosy and everything. Okay, now the dangerous thing comes that if no plan is received, or 330 days are over, or if there is a violation, then we will proceed for liquidation. Okay, now liquidation is about selling the company. So now a liquidator will be appointed. The resolution professional can only become the liquidator, or a new liquidator can be appointed who will sell these assets. He will identify liquidation assets. Liquidation the asset means those assets which can be sold to recover money. You cannot sell off a personal jewelry of if a bank is being liquidated, they cannot sell the locker room thing which is just kept as security to you. Okay, so which can be taken to be sold, which cannot be taken, will all be there. Okay, so let's see. And then the money will be distributed as per the waterfall arrangement. So where the adjudicating authority, before the process, okay, now when they will do, if they did not receive a resolution plan, now we are seeing liquidation process. Okay, now this starts from section number 33, that we did not receive a resolution plan. Okay, or it has been rejected, the resolution plan. Okay, or the committee of creditors have said that they will pass a liquidate the company. 66% have said liquidate the company. Okay, so all these circumstances are there, which will lead to which will lead to liquidation. Now what will happen is, now when liquidation has been confirmed NCLT, then a liquidator will be appointed. Resolution professional can act as a liquidator, or a new person will be appointed as a liquidator. What are the powers of a liquidator? We all know, like we've always done. A liquidator, he'll take control of the assets, determine a valuation estate, and then end the company. Okay, so could be replaced. Powers and duties of the liquidator, section number 35, important, very simple also. Okay, now liquidator will verify the claim, take all the property in his custody, evaluate the assets, okay, take measures, carry on the business till it is liquidated. Then comes section number 36, very important. Okay, section number 36, that the liquidator will prepare a liquidation estate. Liquidation estate means all those estates that will be part of the liquidation, or will be part of the sale. Okay, tangible, intangible, all property will be taken to be sold. Okay, the liquidator will have a power to access all the information as he wants, information, utility, etc. Claims will be consolidated, verification of claims will be done, and they've given you three kinds of transactions. Just remember, preferential transactions, extortionate credit. So just remember, section 43 is about preferential transactions. Then we come to avoidance of undervalue transaction. So there is a undervalue transaction, there is a preferential transaction, and there is a extortionate credit transaction. There is a extortionate credit transaction. What is it? Let's see. Extortionate credit transaction. So when these three happen, the liquidator or any resolution professional can declare these transactions to be void. That means undervalue transaction has happened. So obviously there is a loss. So they will identify that who has done this transaction and declare it to be void. Extortionate credit transaction means, extortionate means unreasonable credit transaction has been done with the objective of ensuring that nothing is given to the creditors, to defeat the claims of the creditors. So this will also be declared void. Okay, and orders will be passed to restore the orders, repay the payment, etc. So these three, just note down, that is also important. Then we come to section number 53. What does section 53 talk about? The distribution of assets. The very first thing that's called as this is called as a waterfall arrangement. What it is called? Waterfall arrangement. Okay, what is waterfall arrangement and in which order it will be given? Priority of payment. First liquidation cost will be given, then workmen money will be given, they'll be in pari passu with secured creditors, then the employees wages. Now employees, not workmen, employees will be given for another who's 12 months who are there unsecured, then the government dues. So all this waterfall arrangement is that you should learn, important. Okay, and then in the end they will dissolve and get a dissolution order. After that the company will cease to exist. Okay, now it ends on section number 54, dissolution order. Section number 54 is dissolution order. Now pay attention to this, that a pre-packaged, now the government introduced something called as PIRP. What did they introduce? PIRP. It is from section number 54A to section 54P. So what is PIRP? How is it different from CIRP? So PIRP is specifically a very beneficial insolvency process given to the MSME, small and medium enterprise exchange. So can a non-MSME come for PIRP? Answer is no. What is the concept? We'll see later, but first understand that this is only and only for MSME. This is only for MSME. Okay, fine. Okay. Can MSME come for CIRP? Answer is yes. They can come for CIRP and PIRP. MSME have an option. Either they can go for PIRP, but PIRP is much better. And we'll see in which circumstances PIRP is possible. So in PIRP, what happens is the debtor stays in control of the assets. As compared to CIRP, what happens? The resolution professional takes all the powers of the creditors and then he sits with the powers. Takes all the powers of the directors and comes. Here what happens? Now let me explain. So here the PIRP I'm explaining. PIRP. In PIRP, it is only for MSME. Now the corporate debtor and creditor, they themselves have an agreement. They have an agreement already before coming to NCLT. They will have an agreement and prepare a base plan. They come to some agreement and they come to a base plan. So only if if agreement could not be done, then the MSME will not be able to come for PIRP. They will have to go for CIRP only. So base plan is required based on agreement with both the parties. So they are not coming as a disputant. They both are coming and coming to the government with a basic plan. Okay. So once you come with a base plan, the creditors, the corporate debtor can remain in control of company. Normally what happens in CIRP? You have to mandatorily come, all the powers of the directors go to the RP. This doesn't happen here. And normally how you have CIRPs for 330 days, this is for a lesser period. We'll see. Okay. So this is the entire difference between PIRP. MSME come, they make a base plan and they also get to stay, the debtor gets to be in control of the resolution. Debtor in possession means he will be in possession of the company only. And the entire thing will get over. Like how you have 330 days, here it is a voluntary process initiated and will be completed within 120 days. So that gets over. CIRP in 330, this gets over in 120. So if you see section 54A, who is eligible for PIRP? Obviously, it must be classified as MSME as per the MSME Act 2006. One. Second, it has to, they have to come. Yeah. Now they have to come with consent. Okay, consent of 66% of the creditors, and even the company has passed a special resolution. So both the corporate debtor and the financial creditor, they both have come to an agreement. So both of them have passed a resolution and they passed a base plan. Then everything else remains the same. The government will just supervise that this is completed as per the base plan. So the insolvency professional appointed shall prepare a report and a conformity of a base plan and file a report with the IBBI, with the board, that listen, these both have come, they prepare a base plan, let's prepare and initiate PIRP where we'll try to revive the company. Okay. The same thing, the PIRP time limit, section 54D, that the PIRP shall be completed within 120 days. The resolution professional shall submit a plan approved by the committee of creditors within 90 days, failing which it will apply for liquidation or it will be terminated. PIRP will be terminated. So 120 days the full thing will get over and resolution plan will come within 90 days. So it's a fast track mode also. Okay. And then once PIRP is there, same thing. And your public announcement will be done. Our resolution professional will be appointed and moratorium will be declared. Okay. Rest everything remains the same. You prepare an information memorandum, etc. It's just the initial who stays in control. So the management of the affairs will be with the corporate debtor only. This is the most important. And one thing is, another differentiation is the RP shall constitute a committee of creditors within 7 days and convene the first meeting within 7 days of constitution. So what happens is, moment the RP is appointed, he will prepare within 7 days, he will prepare a committee of creditors. In the next 7 days, the committee will have their first meeting. Simple. Okay, all decisions will be taken by 66% voting share of the committee of creditors. They will prepare the base plan and try to give a final plan which has to be approved by 66% parties. Okay, so where two things, termination of PIRP, when PIRP will get over, where no resolution plan is submitted within 90 days or not approved within 120 days. So first they said the plan has to be submitted within 90 days and it has to be approved within 120 days. If this is not done, then we'll say that it has been terminated. Okay. So the first meeting is within 7 days. Okay, is within 7 days of the committee of creditors and constitution within 7 days of pre-packaged the commencement date. The COC will be so same thing. Moment the application is accepted, within 7 days COC will be appointed and within the next 7 days the first meeting will be held of this. Okay, with this. Okay, now, so what was it, that submission of the resolution plan is within 90 days from the insolvency commencement date. Non-approval of the resolution, okay, within the 120 days, then it will be deemed to be terminated. So plan has to be submitted within 90 days and has to be accepted within 120 days. With this, we have covered the entire IBC code 2016, and this entire sheet I will ensure it's completely amended till 2025 and you will get it on our website. Okay, thank you so much guys for your